Welcome to the Administrative Law Research Module Series. By the end of this series, you will know more about the federal executive branch of government and the administrative agencies that carry out its daily work. Though our focus will be on federal administrative activity, we will also introduce you to administrative agencies within the context of state government in a tutorial on Ohio administrative law. As you should recall from your high school civics class, there are three branches of federal government. You should be very aware of the judicial branch, since most law school courses use the case law method of instruction. The cases you have been reading are results of judges' reviews of legal issues appealed to them after a lower court decision based upon the review of evidence and testimony. The second branch of government is the legislative branch, which consists of two chambers, the Congress and the Senate, that are elected by us as citizens to make statutory law. The third branch of government, the executive branch, is the focus of this tutorial series. With authority from Congress or the President, the executive branch includes administrative agencies that have the power to regulate select activities in which we engage every day. On this organizational chart from the United States Government Manual showing the three branches of government, the boxes I am highlighting in green represent the executive branch and its administrative agencies. As you can see, this is the largest branch of the United States government. One example of an administrative agency is the U.S. Department of Energy. The mission of the United States Department of Energy, as found on its website, is to ensure America's security and prosperity by addressing its energy, environmental, and nuclear challenges through transformative science and technology solutions. To this end, the department creates and enforces regulation that govern issues like developing clean energy sources. An administrative agency may be developed in one of two ways. First, the President can use the power to create a reorganization plan. In 1970, concerns about pollution led then-President Richard Nixon to issue Reorganization Plan 3 to establish the Environmental Protection Agency. Congress may also create an administrative agency by passing legislation referred to as enabling acts. The Federal Communications Commission and the Securities and Exchange Commission are examples of agencies that were developed by acts of Congress. Once a grant of power has been made, within that delegated authority, the agency may engage in the rulemaking process. The results of this process can be followed in the Federal Register, the daily administrative publication, and are ultimately codified in the Code of Federal Regulations. You will have an entire lesson on the Federal Register and the Code of Federal Regulations later in this series. A brief summary of the rulemaking process is that an agency announces its plans to make a regulation first. Staying with the EPA example, this could be details about methods to prevent lead paint poisoning in residential property. This, you may imagine, would be a subject of interest to any landlord renting homes in older neighborhoods. If a renovation project was planned, that landlord would find that there are regulations in Title 40 of the Code of Federal Regulations providing guidelines to ensure lead paint removal when residential property is being renovated. If the EPA were to plan to change this rule, they would include their plan of change in the Federal Register where attorneys who practice landlord-tenant law could find them. If an attorney thought the proposed change would be good for his landlord clients, he could post a comment on the regulations.gov website or encourage his clients to write in support of the changes themselves. The EPA would be required to consider, in substance, all of the comments that they received as they finalized the proposed regulation. Once finalized, that regulation would be announced in the Federal Register, and it would update the relevant existing sections of the Code of Federal Regulations. An administrative agency may also act in a quasi-judicial capacity. A landlord, for example, unsure of the impact of the rule change, could petition an agency for guidance as to how he would comply with the new regulation. The agency would then write an explanation for the landlord, providing guidance to help him comply with the new rule. The resulting opinion, as you may guess, would be called a guidance document. If tenants feel the change has been misinterpreted in a way that has resulted in less protection of their health, a tenants advocacy group, for example, might bring an action before the agency to be heard by an administrative law judge who would decide the controversy and write an administrative decision expressing his opinion. Agency authority also includes the power to investigate and enforce agency regulations. If the EPA suspects a company has failed to comply with its regulations, it may investigate that company and, ultimately, impose a penalty. It may sound strange that agencies have this breadth of authority. Generally, this is the case because agencies are led by experts in the fields they regulate, and efficiency of having experts oversee a particular area within the delegated boundaries is deemed beneficial for keeping many daily activities going. Keep in mind these things about agency autonomy. The quasi-judicial function of agencies is subject to judicial review in the federal courts, and an agency's authority cannot exceed the power delegated to it by Congress or the President, so it cannot act beyond the bounds of the other two branches of government. There is a lot of information that you may need to know about a federal agency if you are practicing law subject to that agency's regulation. In the electronic age, there is an abundance of agency information on an agency's official website. Though it is improving for almost all agencies, there are still some agencies that do not have well-developed sites that include all of their information and are easy to navigate. For this reason, it is important to know that the United States Government Manual, though no longer published in print, is available through the Government Publishing Office's Federal Digital System. The Government Manual is a one-stop source of information about federal agencies. The entries include the source of authority for the development of the agency with citations for that source. There is also a description of the agency, highlights of its history, its current officers with contact information, and sometimes a full organizational chart. Significant for legal research, many agency entries also include information about the publications of the agency and help finding those publications online. When Richard Nixon acted to develop the EPA, he also created the National Oceanic and Atmospheric Administration through Reorganization Plan No. 4 of 1970. Here is the government manual entry for that organization. As you can see, a citation to the plan leads you to Title V of the United States Code in the appendix of that title. Though printed first in the Federal Register and statutes at large, reorganization plans are also conveniently added to the appendix of Title V. Each state has a governmental structure that mirrors the federal government. Each has an executive, judicial, and legislative branch. You will learn more about Ohio's administrative law in a later tutorial. In the meantime, a good place to locate information about state government structures is the USA.gov page on state governments. This convenient list of links to state web pages will help you find information about all of the branches of government within each state. Let's think a little about what we have learned in context. You are probably aware that the federal government, under certain specified direction, permits federally acknowledged Native American tribes to establish gaming outlets with profits to go toward the support of the tribe. As you might imagine, the federal government is interested in providing direction to tribes with regard to the behavior that is acceptable in the administration of these gambling activities. To oversee the regulation of such activities, the Congress, in Section 2702 of Title 25 of the United States Code, created the National Indian Gaming Commission. Specifically, under Title 25 of the United States Code, Section 2701, subsection 5, quote, Indian tribes have the exclusive right to regulate gaming activity on Indian lands if the gaming activity is not specifically prohibited by federal law and is conducted within a state which does not, as a matter of criminal law and public policy, prohibit such gaming activity. This is the text of the relevant statute as published online by the Legal Information Institute, a reliable, free source of federal United States statutes and regulations. The series of statutory sections in Chapter 29 of Title 25 delegate authority to the National Indian Gaming Commission and provide direction for the application of that authority. Under its congressional authority, the Commission may create regulations that provide more detail with regard to the expectations to be followed by tribes carrying out gaming activities and any prohibited behaviors as well. You can find a list of the relevant regulations that the Commission has created by clicking on the tab labeled Authorities CFR. This is very handy since regulations must also be read in conjunction with the related statutes. Though it is not always the case, both the statutory title in the United States Code covering laws governing Native American issues and the regulations in the Code of Federal Regulations have been placed in Title 25. The sections regulating gaming activity are found in Chapter 3 of Title 25 in the Code of Federal Regulations and span from Part 500 to Part 586, including dozens of related subsections. These should be considered the rules by which tribes govern their daily activities relating to gaming, under which the Commission will review tribal activity for compliance. As you can see, sections are often reserved for future regulations so that the structure of the Code of Federal Regulations may be maintained as regulation in a particular area grows. The National Indian Gaming Commission is given the authority to enforce its own regulations by statute. This means that the Commission may check tribes that engage in gaming activities for compliance, enforce the rules where it finds noncompliance, and assess fines as it finds appropriate within its delegated authority. Sometimes enforcement may be carried out through a quasi-judicial process. If the Commission feels a tribal gaming activity does not comply with its rules to such an extent that consideration of closure of a gaming facility is warranted, it will hold a hearing and make a determination based on the evidence it is presented. By a regulation developed by the Commission, however, it will work with the tribe to cure a compliance issue voluntarily. This provision is found in Title 25 of the Code of Federal Regulations, Section 573.1. This process may sound a bit confusing right now. However, these tutorials will build upon each other and continue to elucidate this process and point you to the documents prepared by the agency at each step of it. Next, you will learn more about the Federal Register, the daily publication of agency activity where new and changing rules or regulations are announced and finalized, and the Code of Federal Regulations, where final rules are published in a subject matter arrangement. If you have questions about this or any other tutorial in this series, please contact Research Services at 216-687-6877 or email us at research.services@law.csuohio.edu.